Welcome to the MedRep podcast. Very excited today to have an attorney. Actually, he's really likes to call himself an entrepreneur who happens to have a law degree. Let me tell you a little bit about this individual because he's about to give us some information from a legal and entrepreneurial perspective that I think is really important to those who are in the medical space. Something, being reps, being distributors, there is a litigious side. We live in a litigious society, and a lot of us have questions. So we're very honored and blessed to have this individual on. Let's talk about him first because he's not your normal attorney, right? Even the way in which he builds is a little bit outside of the box, and that's what we like about this individual that we're speaking with. So the man that you see in the screen right now does it all. I had the opportunity to meet him actually through social media. He is he's a man of many talents. Like I said, he is an attorney. He happens to have a law degree, but he likes to say that he's an entrepreneur that just happens to, have a law degree. He went to law school. He started as an attorney and is really branched out into a number of different entrepreneurial businesses. And started as a young kid, he's selling baseball cards in the schoolyard. So he was kind of innately had that entrepreneurial spirit. And then from there, went to law school, was an attorney, and now really he's more of an entrepreneur who consults other lawyers on how to really run their law practice. And he actually sells a course on it right now, which is amazing. He is a speaker, just actually exited the TEDx stage up in Canada, which makes him an international TEDx speaker. So congrats to you on that. Not an easy feat. He is also an author of an amazing book, which I've read. We'll leave that at the end in the show notes if you guys want to pick it up and get one for yourself. He's a podcast host as well of a podcast called It's Just Work, correct?
Yeah, that's correct.
And he is a social media guru. I don't know when he sleeps, but this guy's got more followers on Instagram, Twitter, and Facebook than any other attorney that I know. So he's really mastered. That's how we met in the social media space. And one little note about him, he's also at one time the state powerlifting champion. So you can tell by the grizzly beard that this man does not mess around in the gym either. And his name, I'd like to introduce you to Mr. Rocco Cozza. Rocco, welcome to the show. That is an amazing name. And for an attorney, I don't know. It's like a mafia-esque type of name. I like it. So welcome to the show, Rocco.
I appreciate you having me. And actually, the reason why I was named Rocco, tidbit, I was born on St. Rocco's Day, August 16th.
Oh, okay. All right. Awesome. Well, it's an awesome name. In fact, his Instagram handle, if you wish to follow, is the Rocco Cozza. And when you type in the ROC, you also get the Rock. So
I'm in good company.
You are in good company. He's got a few more followers, but the Rocco Cozza is you can find him there on Instagram. So welcome to the show. Excited to talk all things medical and contracts related. So,
absolutely.
Now I know you're an attorney, and we kind of got to get a little disclaimer out of the way. So
I talk to a lot of different people about a lot of different things, and I always, as the attorney in me, I have to say that we're going to talk a lot about contracts and setting up entities and the law, but this is purely just education. There's no attorney-client relationship. If you need an attorney, you should definitely seek out one. I'd be happy to work with all of you out there, but this is merely educational in nature. So please don't take any of this as legal advice. That's a disclaimer I unfortunately have to give because that's the way our profession works.
No, I get it. And I guess I'll start with my first question along those lines. You gave that disclaimer for a reason, and fortunately and unfortunately, no disrespect to your line of work, we live in a litigious society, right? So it's very litigious, and it seems to be getting more and more that way. Speak about, I guess, just at a very high level, your opinion of this litigious society, and just as an entrepreneur, or just as a general human being, how one should act in that environment as such.
Yeah, you're 100% right when you say that the litigious nature of society has been amplified, 10x, even since I started practicing law. So I believe, look, as entrepreneurs, we tend to be on the cutting edge of risk. We like to walk up to the line. But in my law practice, I work with a lot of entrepreneurs, solopreneurs, independent reps, small companies, and I work with how do we get as close to the edge as possible, but protecting everything else. That comes down to setting up your companies the right way, building your contracts the right way, making sure you have the right language, you're thinking about the right things. There's so many intricacies that one just can't understand unless you do it every day like I do. I always tell people, that, because there's a lot of people out there that look at setting up the entity or having a lawyer review the contract as an expense. Mm-hmm. I tell people this is an investment. It's an investment in protecting your assets and your future. So especially the way we are today with all the litigation happening, and a couple of my best friends are litigators, and the stuff that people are suing for is out of control. And a lot of the things can be avoided by just simple protections put in place.
Yeah, I've seen it ramp up personally. Yeah. I've seen our law bills go up professionally, and it is what it is. I mean, you're not going to change it as an individual. And like you said, you just need to see it as an investment versus an expense, because I can speak to it from personal experience. When you breeze through that, it's that one or two words, that little thing that you maybe have avoided that just will blow your mind. I remember having to exit a company, and the way in which the contract was written, it was almost impossible to exit the company unless I passed away. So it was a very strangely written. I never read it, because as business people, especially entrepreneurs, you start to link arms with people. You're like, it's going to be great. But you just do, you never know what's going to happen. That's why that piece of paper is so important. So, one of the things we're going to talk about today is ECRA, and we're going to get into that in a second. Yep. But, as an attorney and as a business person, I know you understand our medical space. We've had a lot of discussions about it personally. Kind of give me your general understanding of the, again, keeping it high level, and then we'll go a little bit deeper about that medical space and really the litigious nature, how it's somewhat driven up in the medical space, and how the need for that investment is even of more importance.
Yeah. I mean, so look at it this way. People, when they sue, they look at who has the money. It all boils down to where's the money. The doctors, the medical companies, the hospitals, the medical equipment providers. However, when you are a rep, and we'll use the reps as the example, if I'm sold a product or I'm given a product as a patient, right? Mm-hmm. And it causes injury to me. Well, I'm going to list everybody that had anything to do with that product being put in me or used with me in that lawsuit to recover my damages, and let you guys fight it out. That's why having an entity and having the right contracts and the right language in those contracts in place is so vitally important, because like you said, one or two wrong words or one or two wrong sentences or set up the improper way could mean protected or all of your stuff is gone. And the way the medical, again, I have friends that are medical malpractice attorneys, and it's, they love those cases because they know someone's going to pay.
Yeah.
So you have to make that investment to protect yourself. I truly believe that. It's, I work with a lot of reps in the med space and in just other industries where the same type of model. Mm-hmm. And my advice is, look, for the amount of money it takes to get these things done, you're going to get 100x in protection. If you want to grow your business and do the right things, you have to build the right foundation. That is your entity. That is your contracts. That is having the right people on your team, or the right, someone like a lawyer or your accountant. Those are all important pieces to running your business, and especially in the med space, because it's a high risk business.
Yeah, and it's under a lot of watchful eyes. And there's been a lot of corruption. Crazy. Specifically in the independent space, and with certain products, there's really the compounding industry that draw a lot of attention to this space.
Oh yeah.
And there's some people that went to prison. Not only, obviously you see with physicians, but you see with vendors, you see with reps and distributors. There are people that got in trouble. And when you're in the independent space, it's somewhat of the wild, wild west in that it differs in that if you work for a larger corporation, you have that structure, you have those rules that box you're supposed to play in. When you're independent, you're at home and you have no boss, it's you. And you just a lot of people just assume that I can do what I want. I can say what I want. I can make whatever piece of marketing collateral I want. I can post whatever I want in social. The reality is you need to play by the same damn rules that corporation does. While you may not have the same eyeballs on it because you're smaller, you're still at risk, right?
Absolutely, 100%. And it's just because the eyeballs aren't on you right now doesn't mean they can't come. Like I've dealt with clients that, they started off as that small company, and despite advice I've given them, they've done things a different way because they said, no one's going to see. We're the little guy. No one cares about us. The problem is people do care, and eventually they get to that person. And if you're not, and what I was advising them to do in the beginning was do a few little things. It was going to cost them probably under $1,000.
Mm-hmm.
They got themselves into hot water and ended up paying a $58,000 fine, for not wanting to spend the $1,000 up front because they thought they could skirt the law or fly under the radar. These things happen. And that's why I built my practice the way it is, to work with small companies, to work with entrepreneurs, how I do my billing, because I want people to be able to put the right things in place without having that sticker shock that most people think when they hear lawyer. They think it's billable hours, a ton of money. That's not how I operate. I've done it my way, and that's why I've built my practice my way. Because that's how, if I wasn't a lawyer, I want to work with a lawyer like that because I know what I'm getting. Yeah. But I think people need to get the stuff that I provide, but that fear of cost always drives the decision.
It does. And I think not only is it the fear of cost, but it's also ignorance, right? I think a lot of people, when I work for a larger organization, I didn't know a lot of stuff. I just assumed I could read a contract and figure it out. And the reality is, while I'd like to be a Google lawyer, I'm not, I'm not, right?
I wish I had my coffee cup right now that actually says, please do not excuse your Google search with my law degree.
Yeah, exactly.
I mean, exactly. I have it in my office.
A couple YouTube videos, I'm good, right? So unfortunately, that isn't the case. And sometimes it's not until the snake bites you that you realize it was in the grass, right? So I think people need to be aware of the world and playground that they're playing in. So let's dive a little deeper into that. So the way I look at the law or the necessity for services of someone like yourself is we would work with a lot of distributors and individual reps. So we have representatives that will moonlight with us, or they just work, as a sole proprietor or a single entity, and they're accepting 1099 income from us as we're a stand between a lot of vendors, and we also have products of our own. So a lot of times these individual folks need to set up their structure, and we get a lot of calls and a lot of questions like, hey, should I set up an LLC? Should it be an S Corp? Should it be a C Corp? Should it be an anything Corp? What do I need to do? We'll talk about them first, and then we'll kind of get into the structure of some of the bigger distributors that have structure of individuals underneath them. What makes more sense for an entity like that?
Yeah, absolutely. So I believe if you're doing business as an independent contractor, unless it's like here and there income, $100 here, $100 there, it makes sense to set up an entity for a few reasons. One, just the tax benefit. And I don't want to get into the tax stuff. That's a whole other topic. I'm not a tax lawyer, but there's a lot of tax benefits to LLCs electing to be taxed as an S corporation. There's a lot of different things there, and that's something totally different. But from the liability side, most people, I find that if you're in the medical space, you've probably made decent money throughout your life. You probably have acquired some assets. So you need to protect those. Without that entity, like people think a sole proprietorship is a business. It's not. It's you. There's no legal protection. It's purely you. So if something happens, and even if you have a DBA, like you filed a fictitious name. So, I'd be Rocco doing business as, medical rep company. Doesn't matter. It's not a company. It's me. I get sued. Setting up that LLC or whatever entity they choose puts that layer between you, the individual, and who's ever suing you. So it gives you that liability protection. And, there's the C Corp, there's really, when you look at entities, it's really LLCs or corporations. And the types of corporations, there's the C Corp and the S Corp. I have found that in my practice, in all the years I've been practicing, I have set up one C Corp.
Okay.
Everybody chooses LLCs for this type of work. Now, obviously, if you're going to go to tech company, venture funding, different story. For independent reps like this, an LLC seems to always make sense. Everybody's fact scenario is different, but I found that because they're easy to set up. There's not many corporate formalities you have to deal with. Like with a corporation, you have to name your president, vice president, secretary, treasurer. You have to have a bylaws, a board of directors, annual meetings. LLC, you don't have to, in most states, you don't have to do any of that stuff.
That's
You don't even
nice.
need to have an operating agreement. You should have it for the protections in place, but they're very simple. So you don't have to worry about that administrative hassle of, I've got this entity to deal with. Does that make sense?
Yeah, it makes total sense. And I don't know many people that are in the independent space that have anything outside of an LLC for that very reason.
Right,
I've been
exactly.
involved with a C corp, and yeah, we had to, meetings and minutes and all that stuff. It's somewhat of a pain. I know there's advantage to it, and it's more on the tax side, I think, not so much on the protection side. So you build this veil around you, so to speak. So if something happens, they go after your company, not your house and your car.
Yeah, and so long as you're doing things in the biggest, especially in the independent space, the biggest pitfall people have. So when you set up this entity, you have to make sure it's operating outside of you. So you're actually treating it as its own thing. The biggest mistake people make is the commingling of finances.
Okay.
You have to keep that separate. So if I have an LLC, all of my business income needs to go into that LLC. All of my business expenses come out of it. Okay. Nothing personal is paid from that account.
Okay.
You have to just take a distribution into your personal accounts. The problem is most people, especially the independent space, they'll have their business debit card. They think it's my money. I'm just going to stop on the way home and pick up groceries that I need for the house. Swipe their business debit card. If I'm suing you, I'm going to dig as a lawyer into your financials, find that one transaction and say, you commingled, you can't afford yourself the protection an LLC gives you by treating it that way. So that's a piece of advice. If you take one thing from this, take that if you have an LLC and just never commingle.
Have separate credit cards.
Separate credit
Bank
cards,
accounts, all of that.
And be very diligent on the in and outflow of the money.
And that goes back to the tax thing, because obviously that's where you can keep track of for write-offs. And that's an accounting podcast, but there's tons of benefits in terms of mileage and all different types of write-offs that you can benefit from. And I think people be a fool not to do that.
Right.
So for an individual or even a distributor, obviously an LLC is the way to go. Once you get to a distributor level, a lot of questions we get from not only major distributorships that have reps, that work for them, but also for the individual reps is insurance, right? So liability insurance, you see it in a lot of vendor contracts, and people are like, what is this? Do I need to get it? Is it necessary? There's all different types of, insurance.
Sure.
What's your opinion on that?
Yeah. So I believe in, you should have insurance, but there's different types, right? So with an entity, just getting a general liability policy, they're relatively inexpensive. That protects you from, if you're going out and selling, right? I'm selling on behalf of one of the distributors. I cause damage to the company's computer, or someone trips and falls over my bag. Those types of things it covers. The other thing in the med space you see is product liability. Now, as an independent rep, I don't even think as a distributor it's going to make sense to get product liability insurance because it's very expensive. You want to make sure, though, and that kind of ties into the contracts, you want to make sure in those contracts with those manufacturers or the individual with the distributors, claims for product liability that you would be brought into are covered under indemnification. But, coming back to the insurance, if you're a business, at the very minimum, you should have general liability, because if you're driving to a client or a potential, sales call you're doing, and you hit somebody in your car, that's, if you're on the way there for a business purpose, that business insurance would cover it.
You're working. Exactly. Right. Versus your regular car insurance and liability policy they might or might not have.
Exactly. Because the mistake people make is they think when they have an LLC well, great, I'm protected. Well, that's good. But say you have an LLC that's pretty successful, you're making money, and you get sued for something that liability insurance would cover, and you don't have it, you basically lose all the LLC's money.
Mm.
Even though your personal stuff's protected, if you have a successful business that's generating a couple $100,000 a year in cash flow, that's at risk without insurance.
Okay.
So insurance is that added thing on top that I always advise all of my clients, if you're making decent money within your LLC, get the liability insurance.
And you said it's relatively inexpensive. And
Yeah.
I mean
I've
for
seen
one guy, for like one individual, I mean, ballpark
500 to maybe $1,000 for $1 million policy
per year.
Per year. Yeah.
Oh, okay. Yeah. That's obviously a write-off.
Yeah, it's not very expensive at all.
And like you said, it's that one little snake bite. If you didn't have it, then you wish you had it.
It is. It's
you
so
always
true.
hear the stories, and until it happens to you, it's hard to worry about it. And we've sat as an organization and had these very discussions. Should we get it? Should we not get it? It's early on, it's because you have limited dollars in the beginning.
Yeah, absolutely.
Right? And you have to kind of pick and choose, as you said, what you invest in. And I think, unfortunately, those types of expenses tend to get shoved to the side and then forgotten about, right?
Exactly. Yep.
So, I mean, have you, I would imagine you have, this is somewhat of a rhetorical question, but have you seen those situations like that on the bad side of it? And what can you do as an attorney representing that person that didn't have the insurance or didn't have the right wording in the contract? Like, if you're on the defensive side of that, what type of legs do you have to stand on? Let's turn it around for a second.
Yeah, I mean, that's a great question. And it all depends, because the language of a contract can be so finicky. And that's why, I stress to clients, to potential clients, if it's not me, have someone that does this for a living look at it. Because if you sign that contract that's bad, it's hard to get out of. You're probably going to be settling, because you don't want to go toe-to-toe in court. You're going to spend a lot of money. And 9 out of 10 times, and I don't do litigation per se, but when I'm involved as the subject matter expert within the litigation in, say, a contract dispute or a business dispute where it was a poorly drafted contract that the client did not get reviewed and they signed it, it's really hard to get out of. I mean, you're kind of stuck, and you end up trying to find a reasonable settlement position. There's not like you always see.
All you can do.
Yeah, and the problem you see is people have this. They watch these TV shows. They see these lawyers. They found that one smoking gun that gotcha. That doesn't happen.
Right.
A contract
doesn't happen like it does on Law and Order, is what you're saying, right?
No. Like it's and I get frustrated because I watch these shows. I'm thinking this would never happen in real life. Like there's not going to be one word in that contract that because he put this in, it changes everything. It doesn't happen. So it's always advisable, if you with a contract. The other thing I always tell people is, like you said, but going back to what you said earlier, like we're all buddies. Like you think you're getting in business with someone, what's going on, that person. I always say, when you're writing that contract or that agreement, even if you guys love each other, assume the person that picks up that agreement doesn't know either one of you and hates you both. How will that contract read? Yeah,
that's good advice. It's a tough mindset to try to put on, but at the end of the day, it's that piece of paper that matters.
That's exactly right. Because people, especially with companies, you sign a contract with a larger company, the person you signed it with, you may love, that could be your best friend from childhood. But when that person leaves, that contract's there, that next person, that lawyer in the company, me, I'm the guy that's going to read that and say, what does this say? And if you come and try and say, well, so-and-so, we meant it to say this, and that's how we were doing it. It's not going to fly.
Not going to fly. I mean, if you think about it, that's really what a contract is for. When you've got two parties that are engaged in some sort of business, the idea is that if we can't figure it out, we then go to the paper, right? It's it's the sort of the deciding factor. So I guess to your point, when you get back into court, it's like, well, that's what this says. I mean, I know you meant this to say something else, but sorry. So, yeah. And it's tough, man, because especially the operating agreements, when you get into business with somebody and I got to sit across from you that I've known for so many years and I love and trust and look at you like, I don't know. Maybe it's kind of how I have to view it. And Things can change. Things do often
You have to plan for divorce from the beginning. That's what I always say. You in a business, you plan for divorce. And that's why, again, when it comes to partners working and putting a company together without a lawyer will never plan for divorce, because everybody loves each other at the beginning. We have this great business idea. We're going to make a ton of money. It's going to be awesome. No one likes to think of the what ifs. That's where the lawyer comes in. I don't want to be the rain on the parade, but I sit down and say, hey, let's just think through what would happen if in a year from now you guys hate each other.
Yeah.
Working. What do we do? And that's kind of the process I take people through in the partnership side of things and walk them through that divorce planning, because that's a very important thing.
That's why it's there. That's
definitely
why it's there. So we talk about structure, which obviously is important, getting set up, insurance. Now let's talk about contracts, because I think that's where a lot of people have a lot of interest. So when I speak about contracts, I'm talking about whether I'm a independent rep that has a contract with a distributor, right? So my, whoever's providing me all this value, or a distributor or an independent that has a contract with a lab or a company that has its widget, a pharmacy, anything will stay in the medical world. But obviously this transcends any type of vendor, distributor type of relationship. Kind of walk through, in your opinion, give me like your top 5-ish things that someone should have in a contract from the really kind of both perspectives, if that's not too complex of a question, because there's two sides of it, right? There's the vendor side and there's the rep side. Let's actually steer more towards the rep side, because that's most of the people listening, that applies to them. Top 5.
Yeah, so I mean, there's quite a few standard provisions, but I always say if I'm going to give my 5 outside of the commercial terms, because you assume that whatever the payment, what I'm getting paid, the commission splits, how it's all going to work, that should be in every contract. That's how you're getting paid. So that's I'm going to put that over here in the bucket. So the first thing, especially in the medical space, is indemnification. That is the clause within the contract that says if I get sued for something you did, you're going to cover that. Defense costs, settlement, everything. That is by far number one, because especially in the medical space, if I'm selling medical products, which have high risk for injury, high risk for lawsuits, I'm going to get named in that suit. I don't want to be on the hook to pay for it, to pay for the defense costs, to get my own lawyer. If I'm selling your product and your product causes the injury, you've got to cover that. So indemnification is first. Second one would be your limitation of liability, limiting your liability as the rep. And those clauses typically, you're carving out things such as consequential or incidental damages or punitive damages. You're only going to say, I'll only be responsible for direct damages up to maybe a certain limit. So in contracts, I'll sometimes put, I'm only, if I'm going to do something that causes the company damage, maybe they get sued for some false or misleading advertising I put out, or I told somebody something false or misleading, and this company gets sued. I still want to limit my liability. So I may limit those types of damages and put a caveat in there that says it's my damages or my liability is only up to the amount of fees I received in the past 6 months or 12 months. So really limiting yourself. So those are the top 2. The third would be your intellectual property / work product type stuff. If you're an independent rep, I'm assuming you're going to be bringing your clients to my products. I'm not going to be giving clients. You're going to take my products and go sell them. I want to make sure in that contract that I'm not barred from selling other things to those clients just because I sold your stuff. They are my customers. I bring them in. I leave with them. Again, these are things that on the flip side, they're typically not in those standard agreements with reps. Companies will say it's my customer. Once they're my customer, I keep them. So you've got to make sure that opposite language is in there. So protecting those types of things. The other things would be like your non-solicitation, your non-compete, which if a distributor or a company is going to put those in your agreement, you've got to make sure you vet them. One, I would advise against them if you can, but most companies are going to put some level of them in an agreement. So you got to make sure you're looking at those and understanding what rights you're actually giving up and what's enforceable and what's not, and what you have to do and not do. And the last one would be, outside of all the standard boilerplate, how do you end the relationship?
That's
We're the
interesting.
termination provisions.
Makes sense, right? That's kind of what the whole contract's all about in many ways.
Right.
So, okay. Yeah. So those are all ones. It's funny. You literally list the five that as an organization we often look at. The one that really receives a lot of attention in our
Yeah.
industry, just because it's a competitive space. Like you said,
Sure.
people as reps are coming with their client list, or I may have proprietary product or a vendor has that, is the non solicitation and moreover the non-compete. You often
Sure.
see as a distributor that has individuals underneath them, they may have put a non-compete provision inside of their contract. And there's always been this argument where, like, if I don't technically work for you, right? I'm a 1099, I'm an independent. How am I then tied to you as a non-compete? Let's start with that before we get into the other one, which is sort of the non-solicitation, which is another big one. So what's your opinion on non-competes? Do they hold water? Are they BS? Like, what's your feeling on that?
So I will give the standard lawyer answer. It depends.
Okay.
Because so one, I mean, non-competes are enforced at a state level. So every state has different rules or case law when it comes to non-competes. So whatever law that contract is governed by. So typically when you see a contract, right, it'll have that governing law clause, governed by Pennsylvania law, governed by New York law, typically wherever the company's located. So then you have to look to that state's laws. And how does that state's case laws, or how have the courts decided non-competes? Now, what you're talking about is the non-compete for independent reps. There's the employment side, which we're going to take out because that's not really applicable here. The independent contract, you can, in some states, enforce a non-compete if it's reasonable, meaning you're an independent rep and you're selling my products. So you know the inner workings of my business. You know how my product is distributed, like what the margins are. I don't want you to work for my competitor. I'm not saying you can't be a medical rep. I'm not saying you can't sell anything else. All I'm saying is I don't want you, if I'm company A and company B is my number one competitor, if you work for me, I don't want you going and working for company B.
Yeah.
That can be enforceable. That's a more reasonable, because you're not saying, I'm not telling you you can't work. I'm just saying you can't work or sell products from my competitor.
So if you're going to see language as a rep in there, because a lot of times you'll see the language state, you can't be basically a medical rep. It's written in a fashion that says you can't sell, because maybe the product offering is so broad, right?
Sure.
So it will limit it. So as an attorney, you would advise what in that situation? If you were to see that pretty, we'll call it ambiguous or broad language, you'd like to see more specificity to that.
Yeah.
Because there's an understanding there. I get that. Like, I get why there should be some language like that.
Yeah. I would advise drafting it down to a carve out, like saying, okay, you want us to not do any of this for the world. We're not going to cut off, we're not going to cut off our supply of income. We need to carve out a very specific restriction, so that's, in that situation, that's what I'd advise. Like, I would not sign that. I would say, let's come to some reasonable position where you can protect really what you're trying to protect, and I'm still able to feed my family and work and do the things I need to do. Now, the flip side of that is, if there's that company out there that you just can't get them to budge, will that be enforceable? May or may not. Like, that's one of those broad restrictions. And I've, at least here in Pennsylvania, there's been case law, or I've been involved in cases where a court will say you can't prevent somebody from working anywhere ever. Your restriction's too broad, so they'll strike that entire clause, unless there's a clause that typically when you have a non-compete, and if I'm getting too legal, please tell me, but typically when you have like the restrictive covenants of non-competes, there's what's called a blue penciling clause. It's another clause within that contract that says, hey, if a court deems this clause too restrictive, the court can edit it and make it more restrictive, but still enforceable. Outside of having that clause within that contract, if a court says that non-compete's too restrictive, it just goes away and there's no non-compete. So that's something to watch out for as a distributor, to make sure if you're trying to put that non-compete in place, you have that blue penciling clause.
Blue penciling. Okay. So what states, because a lot of us are national, in your
Sure.
experience, just out of curiosity, are there certain states that are very loosey-goosey versus very straight? Because you said it varies by state.
Yeah. I mean, I don't really talk to all of them, but I would say the loosey-goosey is California.
Makes sense.
I mean, California always seems to be the Wild West and flies in the face of logic, what they do there. It's very counterintuitive, especially from an employment standpoint. It just seems very counterintuitive. They're very employee friendly.
Okay.
You know, I'm in Pennsylvania here, so I know the laws here. It's an employer can typically enforce a non-compete so long as it's reasonable in scope and duration. You know,
makes sense.
Those are, California is the only real outlier that comes to mind.
Okay.
You know,
All right.
everything else, it's degrees, it's like degrees from the middle. It's
Okay.
there's not much difference.
So there's all 49 states, then California. Just
Yeah. I mean, sometimes I feel like it can be its own country.
It's big enough. So, all right, let's transition from the sort of the non-compete to the non-solicitation, because where that comes up a lot is you have representatives that have products, or I'm sorry, well, they may have products, but they may have, a list or some things that need to be protected, and they worry about that. What is a way, what's the best advice you can give to somebody around understanding non-solicitation in this space and how to structure their contract?
So a non-solicitation, it differs from a non-compete, because a non-solicitation says you can do whatever you want. All you cannot do is take my clients or take my employees. So in this situation, it's probably going to be more, the questions you're probably getting are more applicable to clients or customer lists. So that's what a non-solicit, if I'm giving you a contract that contains a non-solicitation, I'm trying to prevent you from taking my customers. So then the question becomes, how do we define customer? If it's customers I brought, meaning I have this database of contacts I made, I want to make sure within that language of that non-solicitation, if they won't budge on removing it, that I put a caveat in there that says, provided this clause does not apply to the list of customers attached as Exhibit A, or any customers that you had contact with before a prior date. There's a lot of different ways to do it, but you want to carve, if you can't remove the clause entirely, which is what would obviously be the first recommendation in the independent space, because you've already built up your customer list. So you're going to bring that to a new customer. So if you can't eliminate it, you just limit the non-solicitation to any customers that may have been gained from your work with this company.
Makes sense.
Direct connection with that company.
Okay.
And here's the other piece.
Prenuptial in a way, right?
But here's the other thing, the piece of advice I would give. And again, I'm speaking Pennsylvania, but other states probably apply this same law as well. So outside of a non-solicit, so say I have a contract that has no non-solicitation or no non-compete. Okay. So there's no restrictions. And I work for a company and I develop a client base. And then I go and work for someone else and take that client base. I think I can because there's no non-solicitation, right? That's the thing. However, there's this thing called the Uniform Trade Secrets Act, where in certain states, Pennsylvania being one of them, customer lists are considered trade secrets. So even if I don't have that non-solicitation, I can still sue you for theft of trade secrets if I can prove you took the customers. So it's something to be very cognizant of.
By state. So there's almost these overriding. Now, let me a question.
Yeah.
I understand certain states have these rules that are sort of attached to the state, right?
Yep.
Do they, if your contract says something different than what the state says, what prevails, the state rules or your contract? If there's something actually written, not in the absence of it, but if it's actually there. How does that work?
The contract would prevail in that instance, because you can, if it's just a law saying, hey, you can't take customer lists, but I sign a contract that says you get to take the customers, you can't have your cake and eat it too. You can't induce me to sign a contract because I can take your customers and then try and sue me under a law in that state, it just doesn't work that way.
Yeah.
In criminal law is different, but we're not talking about that. But here in this situation, like that, the contract would override it.
It's really more in the absence of that language than the
Exactly.
hidden state laws that no one thinks
Yeah,
of come into
exactly.
play.
It's the
Yes,
absence of the language.
that's good to
Absolutely.
know. So
Yeah.
let's talk briefly before we get into ACRA about a non-disclosure, an NDA. We get a
Yeah,
lot
sure.
of that passed around in our industry.
Yeah.
Before I'm going to tell you about our products or our relationship with this vendor, a lot of
Mhm.
people think it's this, and maybe it is, it's this secret piece of paper that if I give you my information and my secrets, or I tell you the name of the company that you're going to be selling for now, because I don't want
Yeah.
you to go around me. So it's usually an NDA non-circumvent, right? So if
Yeah,
I'm a
sure.
distributor, I have a rep, I have a
Yep.
distributor, and then there's the vendor. The distributor often has an NDA non-circumvent, so this rep can't go around them right directly to the vendor. And a lot of times
Right.
they don't want them to know about it, so they slap that NDA non-disclosure on the table. Are those worth anything? And if so, how should they be structured?
Yeah, I mean they absolutely are. I mean that's the whole point of them, is to prevent those situations. And I always tell my clients, you want to structure them in plain language, plain English,
Mm-hmm.
because you have to assume, and I always say, assume that a judge is going to look at that person signing that agreement as Joe Plumber, to use an old reference,
Yep.
that can understand the basic language of a contract. So I've seen NDAs that are 10 pages long. I've seen NDAs that are 2 pages long. The latter tends to be more enforceable because it's plain English. It just says, hey, we're not saying you can't do any, we're just saying we're going to tell you stuff that's proprietary and confidential. Here's
Mm-hmm.
the stuff we're going to tell you. You're not going to use it for your own benefit, for the benefit of a third party. And if you do, we're going to sue you. I
Seems
mean,
pretty
that's really the
straightforward.
essence of
Yeah.
a non-compete or a non-disclosure agreement. It's that simple, but too many people try and overcomplicate it with all these different provisions. And I think the more complicated you make it, the less likely, in my opinion, a court would enforce it.
Makes
It's
sense.
too
It's almost like you have
complicated
too
agreement.
much specificity to it. And
Yeah.
if you miss that one little part, they have a little
Yeah.
angle they can take. So, all right, let's talk about the much anticipated
Yeah.
ECRA. First, I guess let's start with kind of explain what your understanding is of ECRA, having read the legislation,
Yeah.
understanding of it, and then talk about your feelings on the impact it may or may not have
Yeah.
on the industry.
So I look at ECRA as a very terrible unintended consequence. So the purpose of the law, the Support Act, and then ECRA as being part of it, was to prevent patient referrals in the substance abuse space, we'll say, to
Mm-hmm.
make it simple. Like they were trying to prevent people from referring people to other substance abuse clinics or labs and just not in overbilling, not billing, not providing the service, like that whole fraudulent piece of the market.
Mm-hmm.
The problem is they lumped in there any laboratory. And the definition of laboratory is all encompassing. So
Mm-hmm.
it didn't limit it to laboratories that deal with substance abuse or substance related type, issues. It is everything. And then the things it says you can't do is you can't pay people based upon the amount of remuneration based upon the amount of referrals, the amount of sales, or the volume. So it kind of what reps do, get paid for volume, paid for, you can't do. It's technically illegal under this law.
Mm-hmm.
I think, and this is my opinion, reading the legislation and how everything came to be. I don't think this was an intended consequence of this law. I don't, because I mean, the federal anti-kickback act that deals with Medicare, Medicaid. There's exemptions for the type of work sales reps do,
Mm-hmm.
or the type of payment schemes. That's not, they're not in this law. So I think it was a very bad unintended consequence. Will Congress go back and rewrite it or change the language? I don't know. I think it's causing a lot of pain and a lot of pressure in the industry because you have to find new ways to compensate people. That's the problem. And it's, I don't think anybody's figured it out yet.
They haven't. It's a mystery, and
Yeah.
we've spoken to a number of vendors. and a number of different individual reps, and everyone has their opinion of it, because at the end of the day, there's language, then there's your opinion. Wouldn't you agree, as an
Exactly.
attorney?
Exactly right. Yep.
And the interpretation of that.
Of course.
So how does something like that, because there's a big uproar in the industry. I mean, you've got
Yeah.
huge corporations like LabCorp and Quest, some
Yeah.
of these massive industries that are
Yep.
now having to change how they do business and how they pay individuals. And then
Hmm.
there's the little guys, kind of going back
Yeah.
to what we talked to in the beginning of the conversation, right? You've
Yeah.
got the big boys, then you got the
Yep.
little guys. And I think the position of a lot of the smaller labs is like, we're just going to kind of wait and see what the bigger folks do and then act
Mhm.
as such, or we're just going to do business as we normally do because no one's given us an answer yet. What would you suggest, to some of those folks, kind of walking down that path?
Yeah. I mean, my suggestion would always be figure out a way to fall within the letter of the law. And that's really, it's hard because, like you said, there's these big companies out there, and I think there's going to be some massive lobbying efforts, coming in this term to really try and get that law changed, because I don't think that was the point of this law, to change the way reps, you guys are all it doesn't make sense. It crushes an industry. Now, there are schools of thought out there where people are saying, okay, well, this could maybe change the way the industry works for the better. There could be different compensation schemes. We can, now it's not so driven by, these having to do these referrals and all. It's maybe on volume of like calls you make, or there's all these different thoughts out there. No one's really pinned it down.
Mm-hmm.
And for me to advise someone, I would say, look, let's look at the law and figure out how to do within the law until we're told otherwise. Because be it you're big or small, it's still a criminal act. It's not something that you can get a fine, but you could also go to prison. And that's what people have to understand. It's not something that, should be taken lightly. Now, again, like you said, there are opinions
Mm-hmm.
on this. There are opinions, and will the Department of Justice prosecute everybody for compensating sales reps the way they've always done it, the way that isn't illegal under the Federal Anti-Kickback Act? I don't know. I can't tell you one way or the other. I would like to think that they wouldn't, because that wasn't a consequence or wasn't an intention of the act, but no one knows. That's the problem.
So what advice would you give to representatives that have a relationship with a vendor, right? That
Mm-hmm.
vendor is paying you as a rep or as a
Yep.
distributor, to have a layer of protection in between you, because
Yes.
everyone has their opinion, as you stated, Rocco,
Yep.
and their opinion may be wrong. So how do I protect myself, or how do these individuals and representatives protect themselves from the wrong opinion?
I would make sure that, as a rep, you're signing a contract with this company or this vendor. You make sure within that contract, if I'm representing a rep, I would say, I want specific language in the indemnification provision that indemnifies me from any liability under ECRA. Because
So
I'm not
specifically
telling you how
state
to pay
ECRA.
me. Exactly, specifically, because the vendor's deciding the compensation structure. They're deciding how the reps are paid. The reps are just doing what they're supposed to do to make the money. So why should I, the rep, be held liable? And it goes more towards the payer anyways, because,
Mm-hmm.
the rep's probably not going to be liable, because, it's knowingly and willfully paying someone for volume of business, referral. So it's really the payor liability.
Makes
There's
sense.
not going to be live, but still, I would still, if I'm a rep, add that language in there, even if it may never come up. It's just that added layer of protection. It's adding a sentence or two to your contract.
It makes
It's that
total
simple.
sense. Yeah. Rocco, you've been a wealth of knowledge today. Greatly
Thank
appreciate
you.
your time.
Of
Thank you
course.
very, very much. And we will be talking to you again soon.
Yeah, absolutely. I appreciate it.
All right. Thanks.
Cool.